Hello friends, in the series on the income tax cases, today we will discuss a very important case in which the issue before the Honorable Bombay High Court in the writ petition was that if the assessment has been completed on the basis of reasons which were supplied to the assessee and the reasons which were given to the commissioner for taking his approval were not the same or they were different, whether in these type of cases the assessment completed under section 147 is valid or is as per law. This issue has been taken up by Honorable Bombay High Court in the case of Floyd, Filandro, Linhares versus Income Tax Officer and others. This case is reported in 473 ITR at page number 587 and the date of the judgment is 7th August 2024. This case relates to the assessment year 17-18 and the facts of the case are very interesting. In the present case, the reasons were supplied to the assessee along with the notice under section 143 subsection 2. The assessee objected to the reasons and the assessee's objections were disposed of by a non-speaking order. The order which was passed for the disposal of the objections of the assessee were very vague and that order was non-speaking order. After that, the assessment order was passed, and when the assessee challenged this assessment order into the writ petition, the revenue came with an affidavit and narrated in that affidavit that the reasons which were supplied to the assessee were different and the reasons which were supplied to the commissioner for taking his approval were different. But it was very clear from the facts that the assessment which was completed was based on the reasons which were given to the assessee. When this matter was heard by Bombay High Court, the court said that in the present case, the assessing officer has not disposed of the objections of the assessee by a speaking order, so there was a clear-cut violation of the Apex Court judgment in the case of JKN Drive Shafts India Limited versus Income Tax Officer 2003, which was reported in 259 ITR at page number 19. Hence, the Bombay High Court quashed the assessment proceedings on the basis that the disposal of the objections of the assessee was done in a very reckless manner and the assessment was completed on the basis of reasons which were different, which were supplied to the assessee and the reasons which were given or to the Principal Commissioner of Income Tax for seeking his approval. When the court was writing his order, in that order some remarks were made by the court regarding the functioning of the income tax officers. The court said that it is seen from the reply affidavit is something which is not only disturbing but it is very quite surprising, which compounds the carelessness approach of the assessing officer. The court said that it is a classic case where the assessing officer has acted quite recklessly and in an irresponsible manner. The court said that the court do not expect and such type of approach of the assessing officer, and the court said that we do not know what happens to such type of officers after passing these type of orders. The court further narrated that the court is also in a very dark that whether any action is taken against such type of officers. The court further said that in the present case, the assessing officer has grossly failed to diligently discharge his duties which are expected from a assessing officer. The court said that whether any inquiry or any performance audit or any vigilance is conducted against these type of officers or not, it is very quite surprising. And the court further said that when these type of assessments are done, the large amount of a very large amount of revenue sometimes is not brought to tax because of the carelessness approach of the assessing officers. So in the nutshell, the court made very serious remarks against the functioning of the assessing officers and at the end quashed the assessment proceedings on the basis of vague reasons which were supplied to the assessee and the reasons which were given to the principal commissioner of income tax for seeking his approval. At the end of this video, once again I am repeating the name of the case. The name of the case is Floyd, Filandro, Linhares versus income tax officer and others, and this case is reported in 473 ITR at page number 587 and the date of the judgment is 7th August 2024. Thank you friends.